What if I told you someone actually copyrighted the word the? No joke, the most common word in English, used billions of times a day, somehow ended up as someone's intellectual property. But how did this even happen? Good question. Did he sue everyone who used it? And does this mean you actually owe him money right now? Well, today you're about to learn the unbelievable true story behind the craziest copyright claim you've ever heard. I'm not sure how many copyright claims you've heard, but this is the craziest. Now, before you panic, relax. You're probably safe. I don't think anyone's coming for your lunch money. But the story behind this copyright battle is both hilarious and fascinating, revealing just how weird the law can get when combined with sports, marketing, and money. Let's rewind though to where it all started, with one of America's largest and most powerful universities, the Ohio State University. Notice how I said the Ohio State University. That's going to be a very important fact just in a moment. All right, Ohio State University, known nationwide for football, huge fan bases, and extremely devoted alumni, has a reputation that precedes itself. If you've ever met someone who went there, you know exactly how seriously they take the word the. I mean, I guess they just like the word football, I don't know. Since its founding in 1870, Ohio State had always casually used the before its name. But things changed dramatically in 1986 when the university officially rebranded itself as the Ohio State University. At first, people thought it was just a quirky bit of branding, but this wasn't just any name change. It sparked an intense rivalry and national debate, and eventually a legal battle that made headlines across the world. Although if you've never heard of it, I don't know how great or big the headlines were. But fast forward to 2019. Ohio State decided their branding wasn't protected enough and wanted exclusive rights to use the on merchandise like t-shirts, hats, and hoodies. They filed a trademark application with the United States Patent and Trademark Office, the USPTO. The internet went absolutely wild. Headlines screamed, Ohio State wants to own the, and social media erupted with jokes, memes, and of course, lots of criticism. You see, people found it ridiculous that anyone could trademark such a common word. I mean, after all, the or the is literally everywhere. Imagine owning something used every few seconds in almost every sentence. I think I've used it a ton already. Things got even messier though when famed fashion designer Marc Jacobs entered the chat. Just months before Ohio State's trademark request, Marc Jacobs had also filed to trademark the word the for his own clothing line. This created a legal showdown, an absurd, confusing battle between a massive university and a globally recognized fashion brand. Who would win the right to use the word the, though, you ask? Would either claim actually hold up in court? Well, let's take a look. Here's where things took a wild turn. The USPTO initially rejected Ohio State's application, calling it merely ornamental, and stating that such a common word couldn't function as a unique brand identifier. But Ohio State wasn't giving up that easily. I mean, they're the Buckeyes after all. Lawyers argued passionately, claiming the use of the word the was distinctive and integral to their brand identity. Who knows? That's what lawyers are paid to do, I guess, argue. Meanwhile, Marc Jacobs faced similar pushback. It looked like no one would own the, but shockingly, after months of back and forth and intense legal arguments, Marc Jacobs' trademark was approved for use on clothing. Ohio State, however, wasn't done fighting. In response, Ohio State doubled down, submitted mountains of evidence, and launched a campaign proving the distinctiveness of their use of the. Alumni rallied behind their beloved the, flooding social media, buying merchandise, and emphasizing it everywhere. And then the unthinkable happened. In a stunning reversal, the USPTO eventually caved. In 2022, just 3 years ago, Ohio State officially won the trademark for the word the for use on branded merchandise. This means they now legally own the, but only in specific contexts related to their apparel, so don't worry. This didn't stop the public ridicule though. Late night shows mocked them, competitors poked fun, and even other universities started jokingly emphasizing words like and, university, and of. So did Ohio State start suing everyone for saying the? Thankfully, no. Trademark law doesn't work like that. Owning a trademark simply means exclusive use in specific commercial scenarios, meaning Ohio State can't stop you from using the word the, or me, just from selling merchandise branded with the. So you could say the all you want, and you should be safe. As ridiculous as it sounds though, this story highlights some fascinating points about intellectual property law. I don't think I've ever said anything fascinating about intellectual property law, but here I just said it. Trademark law isn't always about owning words. It's about associating words with specific brands in consumers' minds. And I can't talk. Ohio State's relentless pursuit wasn't just about ego. It was about money, branding, and creating an unforgettable identity that sets them apart from everyone else. I don't know. I guess they did that with the word the. Who knows? And love them or hate them, you have to admit it worked. You're never going to hear the phrase the or the Ohio State University the same way again, or maybe the word the again. Want more mind-blowing stories of crazy trademarks, insane lawsuits, and weird legal battles? Well, click the video right here to learn how Taylor Swift trademarked the most ordinary phrases ever and got away with it. Trust me, it's even crazier than this.